Session can start. Thank you.
Thank you. Good afternoon, everyone. Let me thank Paolo Buccirossi and the whole team from Lear for the kind invitation. It's a real pleasure being here today. Let me introduce you to the speakers in our panel as well. From Brussels, my partner at Linklaters, Anna Maria Mangiaracina. On my left, Nick Root, who's lead counsel, group competition at Vodafone, and Mauro Ambanelli, data protection officer and group compliance officer at Chiesi Farmaceutici. As you might have seen, our panel today will address the latest theories of harm in antitrust and merger control. We will focus in particular on labor markets, no-poach agreements, wage fixing agreements. With Nick, we will then tackle remedies, the latest in remedies, especially regarding the telecoms market and digital. Anna Maria will comment on that also with respect to remedies in different spaces, in different industries, pharma in particular. And we'll then introduce our last topic concerning the interaction between antitrust and data protection, opening the floor to Mauro, who will then conclude with a few interesting thoughts on the recent Meta judgment from the European Court of Justice and the impact that that might have in the pharmaceutical industry from an in-house counsel perspective. I have to say that when we needed to choose what subjects we would have covered in the limited time available, we had plenty of choice because, of course, much has been happening recently. There have been a number of developments in recent years, a number of challenges for competition authorities in Europe and elsewhere. We've seen authorities being confronted with new challenges, sustainability issues, for instance, but also we've seen authorities needing to adapt, to adopt new instruments, foreign subsidy regulation, the DMA, and the likes. So, of course, there won't be time to talk about all of these, and we will focus only on the topics that I've anticipated. So, coming to the first topic, antitrust and the labor markets, no-poach wage fixing. In this respect, much has been happening lately, really. I guess everybody is aware of what a no-poach is and wage fixing agreement as well. No-poach, essentially those sorts of agreements between businesses where the parties agree not to solicit or hire each other's employees. Wage fixing agreements aimed substantially at agreeing the remuneration or other aspects of the employees' benefits. This is a wave that comes from the US in the first instance. So I'll focus a little bit on what is happening in the US recently because that teaches some lessons also for us Europeans. And then we'll touch upon briefly about what is happening in Europe as well. Of course, we do not have US only in Europe. There are, plenty of things going on elsewhere. But again, in the interest of time, we will focus on these two geographical areas. So, the US. The US is, the jurisdiction where all these stream started back in 2010, so it's a long time ago now, in a no-poach case between Silicon Valley tech companies. That was a civil case, and there have been plenty of civil cases. I will focus a bit more on the criminal angle because that's interesting. In 2016, that's a bit of the turning point when the Department of Justice and the FTC basically published the antitrust guidance for human resource professionals. They said pretty clearly that a lot of focus would have been put on these sort of practices. And that is actually what happened. Since 2020-ish onwards, we've spotted at least 7 criminal cases started by the DOJ. 2 of these are still pending. All of those have gone to trial in court, and 2 of those are still pending. These are the surgical care affiliate case, a no-poach case, and the Lopez case, wage fixing case, still pending. Out of the remaining 5 criminal cases which have gone to trial, 4 have not resisted the test in court. In other words, all the defendants have been acquitted. And this is interesting. The only case where the DOJ actually won in court is the United States versus He, which is a peculiar case because the defendant admitted the wrongdoing, essentially. So I'll just focus a little bit on the other 4 cases. So the Jindal case, which is the first wage fixing case, Davita case, the first no-poach case, Patel, again, no-poach, and Manahi. All of these have been, as I said, all the defendants in these cases have been acquitted. What has happened? Essentially, the DOJ is pursuing these cases under the per se rule, right, being criminal cases, so not under the rule of reason. And with various degrees of reasoning, but in essence, the court have often clarified, and they did particularly so in the Patel case, that the government should have proven a little bit more the existence of anti-competitive effects, even though, again, that was under the per se rule. Another couple of interesting developments in the US which show the level of interest in the topic are the following. First, in January this year, the FTC published a notice of proposed rulemaking, so essentially a proposed new rule that would ban employers from imposing non-compete agreements on their employees. So this is a completely different ballgame than what we've been discussing so far. So we're not talking about agreements between companies. We are talking about the relationship between the employer and the employees. So this really goes quite far. There have been a lot of comments on this new proposed rule. More than 20,000 comments have been received as far as we understand. So we understand this has been put on hold for the moment, and don't expect anything final to come up before 2024. Second point, the new merger guidelines in the US adopted in July. They now include pretty explicitly the concept that the authorities will take into account in their analysis whether the merger substantially lessens competition for workers. Moving to Europe. In Europe, we know that the European Commission, including Mrs. Vestager, already a couple of years ago now, have highlighted in a number of public occasions the intention, the fact that these sort of conducts are under the radars of the European Commission as well, even though we do not have cases from the European Commission open still yet. The national competition authorities in Europe have been more active, vice versa, already, and we see 2 different phases. A first phase, which goes, from 2010-ish until 2020-ish, where basically a number of national competition authorities have started tackling these sorts of conduct, but in the context of wider cartels, as a bit of something broader. And the Spanish authority has been particularly active in this respect, the French authority, the Hungarian authority, somewhat also the Italian authority. But it's only in 2021 onwards that national competition authorities in Europe have really started opening cases on a standalone basis. So naked no-poach agreement, naked wage fixing agreements. And we have found at least 8 of these cases so far, 4 of which concern the sport sector. That's the case, for instance, in Poland, basketball league, Lithuania, again, basketball league, so beware if you play basket. Polish competition again, Polish competition authority again, Motorsports Federation and Speedway League, and the Portuguese competition authority for football fans on Professional Football League. There have been 2 additional cases which have been closed with commitments, one in Greece, the elevator case, and one in the Netherlands, the supermarket case. An interesting case in Romania, the specialized motor vehicle case, interesting because this was kicked off following a whistleblowing procedure, which is interesting from an Italian perspective, given the Italian competition authority has also recently its own whistleblowing process. And we've got a pending case in the IT sector in France. Of course, there would be plenty to say about each of those cases. Most of those are wage fixing cases. There are some no-poach cases as well. Again, what are the theories of harm here and what lessons can be learned? Are these really new theories of harm? I'm not sure entirely, because essentially what we see is that the authority tend to equate or at least assimilate no-poach agreements to some sort of market allocation agreement and wage fixing to price fixing somewhat. I'm simplifying a little bit, but that's the line of reasoning. And we know that this resonates also with the thinking of the European Commission, at least when it comes to wage fixing, because the European Commission has been pretty clear that they will see agreements to fix wages falling into the box of buyer cartels. They've said that pretty clearly in the new horizontal guidelines. So, these cases are also being pursued typically as by object case. Is that the right approach? Again, I'm not entirely sure it's the easiest approach. I'm not entirely sure it's the best approach. Out of these 8 cases that I mentioned, only one, the Lithuanian case, has already undergone the appeal stage, so it's the only one where we already have a decision in the first instance, has been gone judicial review, it's been annulled as well. So, I mean, in my view, the lessons learned here, and again, taking a look also at the US and what has happened there, is that we should be careful in treating these sort of cases as by-object cases. These sort of labor market agreements or conducts, let's call them as we like, mainly affect workers, right, in the first instance at least. And so consumer harm, if any, is only indirect when it happens. So again, I would consider it twice to go under the downhill route of the by-object case. I think I should stop here. I'll leave the floor to Nick. Nick will share with us also some thoughts, even in this respect of the no-poach world, given his recent experience on that side. Thank you.
Thanks, Lucio. I'm assuming the microphone is working. I mean, it's in the public domain that Vodafone has been involved in a no-poach investigation in Turkey. I obviously can't talk specifically about the facts of that case, but I suppose what I can say is that based on our experience, authorities are not simply going to go away if you say, oh, but look, we clearly have all the right compliance processes in place, You have evidence of communications internally that go beyond the formal compliance processes, training, if you like. So they're taking a pretty strict approach. Even things like, if you say to them, well, you can see that with the companies involved in this investigation, hiring has continued to happen between them. You're not going to get them to go away without digging really far, just on that basis. And then I suppose a related point that I'll make is, it probably goes without saying then, it's important to go and make sure that the business, and in particular human resources and people involved in recruitment, are really aware of this heightened risk. I mean, it's certainly something for us that we've made, for example, our HR team aware of before, that's competition law is relevant for you. This sort of issue is something you need to be aware of. But in light of the increased focus, first in the US and now in Europe, it's something that we found going back to them that it has actually been quite an effective way to get their attention. It's sort of something that they say, they were aware of. They knew that we'd mentioned it to them before, but I think giving them these specific examples of very recent cases, and certainly for us with the European footprint, saying, look, it's happening in Europe, has caught their attention and led to some, I think, quite productive discussions about, okay, well, what in practice, what else do we need to do then, if it's beyond just making sure that our teams have competition law training, however often they're supposed to have it. And so it's I guess just a practical view from me as an in-house competition lawyer.
Thank you. Would you like, Nick, then to introduce your topic on remedies?
Yeah, I mean, I think we were just going to give a bit of an. I mean, obviously, I speak particularly from someone in the telecom sector, but I think another topic that we wanted to cover today was just to give a bit of an overview of, the types of remedies that we're seeing, a few of the recent examples, and then I think Anna Maria and Mara perhaps going to contrast with what we're seeing in different sectors as well, and show the range of what the authorities are looking at. I mean, it's not rocket science for most, if not all of you, but the key sort of types of remedies we see are either sort of structural divestment remedies or access remedies, most often, in my world at least. So when you're talking about access remedies, you're looking at a transaction where one or both of the parties to the transaction where one or both of the parties to the transaction is vertically integrated. There's a concern that post-transaction they might withhold or make it more difficult for others in the market downstream to get access to certain inputs. And so the authorities require the merging parties to commit to give access. Access remedies tend to be in place for quite a long time. I mean, certainly one that, in one of our cases that I've worked with Anna Maria on, we have an 8-year access remedy in place. And they normally come with requirements that the parties will give that access will be on transparent, non-discriminatory, FRAND type basis. And what that means in practice may well have to be tailored to the specifics, or usually will have to be tailored to the specifics of the markets that you're talking about. The Commission will want to understand, well, on what terms, on what basis is access usually given in this market, and try to ensure that the potential beneficiaries of the remedy will continue to be able to get access on that basis. The access might be, for example, to a particular technology. So often if the merging parties have particularly important technologies that other people need to interoperate with, to use in order to continue competing, then you'll be asked, parties will be asked to give access to that, and that in itself can pose challenges, because how you give access to a technology can be pretty complex. I think a recent example, relatively recent, it was in Meta Customer, where Facebook, now Meta, acquired Customer, which is a provider of a technology that allows companies to deal with sort of customer service aspects of their relationship with their customers. And Meta was required to commit that it would make available to third parties APIs, that would mean third-party providers of similar technologies to what customer provides, so customer service type technologies would be able to interoperate with WhatsApp, with Facebook Messenger. So I think that's a fairly good example of the type of thing that we see. Another example would be access to infrastructure. I think especially in my world, in the telco world, where one or both of the parties own infrastructure that others require. For those of you that know telcos, you'll know that you have telecom operators. They own their own infrastructure, and then they also sell services to customers using that infrastructure. You then have other operators, often called virtual operators, who don't own the infrastructure themselves. They effectively rent it from somebody else. An example there is Vodafone Italy and Telecom Italia put their mobile towers, the ugly towers that you see on the streets and on top of buildings and in the middle of fields, put those into a joint venture company, Inuit, and that was a notifiable merger in Brussels, and were required to give a commitment that the JV would ensure that there was access to enough of the towers that the JV owns to third-party telco operators in Italy to make sure that they could continue to provide good quality service in competition with Vodafone and Telecom Italia. I think that's all I'll say in terms of describing what types of remedies we see. I think thinking a bit more practically, once you've got the remedies, you then have to implement them, and that can be pretty challenging, time-consuming, complex, expensive in practice. Again, thinking more, with my in-house hat on here, you might well have a monitoring trustee. That's someone that's officially appointed by the Commission, but usually the Commission is open to suggestions or recommendations from the parties. The parties will need to find a trustee that has a track record that can prove that they understand the markets that you're in. So they will be able, they're not going to have the wool pulled over their eyes by the parties, making out like things are, much simpler than they really are. And sometimes actually, as in the case that I've just mentioned, we had to find a monitoring trustee who would be supported by a technical expert, because the infrastructure that we were giving access to does, in order to be able to, for the trustee to be able to ensure that the parties were giving access on the right basis as agreed in the commitments, they needed a technical expert to support them to make sure that, for example, Vodafone and Telecom Italia weren't saying to the trustee, oh yeah, we're making them available, it's very easy for the third parties, they shouldn't have any complaints, what's their problem? There's a technical expert that supports the trustee that tests that with us, or says, no, I know how this market works, that's not how how access to towers is provided on a commercial basis. So already you can envisage there's quite a lot of people involved. That involves managing a lot of different personalities with different priorities. Obviously when you're dealing with a trustee, you're thinking, well, they are really the Commission's representative. They're the Commission's eyes. They're reporting back to the Commission to tell them whether or not the parties are complying with the commitments that they've given. I think one thing I'll say is that if you manage the relationship with a monitoring trustee well, the trustee can be helpful as well, because if there wasn't a trustee, you might be faced in a sort of access remedy situation with third parties, either coming to the companies and sort of making trouble, saying, well, you're not complying with your commitments, you're not giving me enough, you're not giving me what I want, or just going to the Commission. And actually the trustee, if they understand well the situation, they can be quite helpful in terms of they act as a filter or someone. They're the first port of call for the third parties if they have complaints or concerns that they want to raise. The trustee will then bring them to the parties. You have the opportunity to explain your perspective, and then ultimately the trustee will say, look, well, this is what we think you need to do to comply, and if there's a real difference of views, then they'll go back to the Commission. And but I think the point I wanted to make is, yes, look, there's a lot of work in the process of dealing with implementing commitments and monitoring trustees, but I think my experience is that, if you manage that relationship constructively, there can also be some positives once you're sort of lumbered with the commitments, if you like, in being able to implement them. The last point I think that we thought we might touch on is the possibility of waiving remedies. That's not something actually that I personally have experience of, but I think Suffice to say that that happens pretty rarely. The test for waiving a commitment once it's in place, or the threshold is very high. You need to show significant permanent changes in the market. You need to show that a significant amount of time has passed since the decision putting in place the commitments was issued. I guess because otherwise you wouldn't be able to show that the change was permanent. I don't think I need to go into any more specific detail on that. I'll hand over to Anna Maria then to sort of draw a comparison with some other industries.
Yeah, thanks, Nick. Hi, everyone. So what I was just going to say is that on the point of waivers, I think it links nicely to the point about different approach of regulators, which was going to be only my comment when it comes to remedies. So you all know, and some of you will know better than others, that there are some regulators across the world that really hate behavioral commitments. They just think it doesn't work. And one of the reasons why is exactly monitoring. You need to monitor. It goes on for quite a long time. And this is why in Europe sometimes, vice versa, we see conversation with the Commission around waiving commitments or amending what the commitments, particularly behavioral ones, because after 5-6 years, market have changed, other players have merged, so actually the competitive dynamics are not the same. So the only comments I was going to make on remedies generally is that I think we will see more and more question when it comes to clients asking us, how do you think this is going to turn out, where we will not be able to give an answer which says, with this remedy, you're going to fix it across the world. I'm afraid you will have to think about different solutions for different regulators with industry like digital, tech, and also healthcare, to be honest, where being in an industry that moves quickly, or when it comes to healthcare, an industry where there is a lot of uncertainty as to what's going to happen, regulators like the European Commission are willing to take a bet and accept some behavioral commitments, also as a mix-up with divestment, while other regulators like the CMA we have seen recently are very clear that they think just a structural change in the market can fix the issue. And this is not always possible. So I was just going to say that, it becomes more challenging. We heard it also this morning for us as external advisor, but also for those who sit in an in-house role, to advise on consistency. Unfortunately, the outcome sometimes is not consistent, which is not helpful for business, but I guess that's also what we need to be able to navigate through. I think with Mauro, we wanted just to bring you to the point about, I thought it was interesting this morning, there were already comments around how much data have become important for us antitrust lawyers. And kind of just some reflection of what it means when you don't only look at data, but also GDPR and compliance with GDPR. So you will know that, in the regular assessment of competition law that regulators do, there has been a question over the years whether factors other than price should have an impact in terms of, is there a value for parties, being merging parties or, being parties in a 101 or 102 investigation. And I think over the years you have seen the evolution in Europe, but elsewhere around how data can be a factors of competition, and owning a lot of data, managing those data is important. So we have seen a number of merger decisions, starting from those where Commission was really hesitant to take into account data. Take a Google double click, they clearly said, look, data is not for us, it's data protection regulators, is not for us to look at. But I think also with the timeline moving, GDPR coming into force in Europe, that meant that also competition regulators were asked to look at this set of rules. Because if I step out, if I look at from a client perspective, before GDPR, the usual question was, if I can put it that way, from clients, what's the risk that I infringe data protection versus competition law? And you would tell them it's much more expensive on competition law, so just please ignore a bit data protection. Just do the minimum, but just go with it. With the GDPR, the consideration have completely changed because the fine is important. It goes on every newspaper, and also you have GDPR regulators across Europe that speak to each other and bring proceeding across. So I think that also has influenced somehow how the Commission and other national competition authorities have started to realize that actually data is important, and particularly in a merger context, acquiring a lot of data or being able to manage data and information does have a role, and privacy consideration do have a role in the competitive assessment. So you have seen other cases that come afterwards, Microsoft LinkedIn, Google Fitbit, and all the consideration around what happens with the information that Google gets through the watches that you bring. And then we come to July this summer with the Meta judgment, which is a very interesting judgment. It's a reference from the German authority. And effectively, the ECJ in Luxembourg concluded that, when asking yourself whether the behavior of a dominant company can effectively represent an abuse of 102, so an infringement of competition law, competition authorities should also assess, the compatibility of those behavior with GDPR as part of the circumstances. So effectively opening the door to say GDPR is part of your assessment, is part of something that you need to look at. Needless to say, national competition authorities, with all due respect, are far away from having the means to run that analysis, nor they know. Plus, there is the usual, who I'm the data protection officer, you are competition authorities, or who everyone should keep in their place. But I think what is interesting, and I'll let Mauro comment, is how a judgment like this raises a number of very practical questions from a compliance perspective, particularly if you're in an industry where you need data to run your business, and where users want to give you their data for you to run the business effectively, and in case of a pharma company also to be able to really address their needs. So I'll let Mauro comment a bit how that has impacted your kind of compliance work as well.
Yes, thank you, Anna Maria. Yes, you are absolutely correct. In the group I work for, I'm both a compliance officer in charge with antitrust issues and data protection officer. And before the Meta judgment, I was pretty relaxed in considering those activities as two planets with the independent orbits that should never get in touch. Of course, as Anna Maria mentioned, they got in touch even before this decision, but mainly during M&A's operations. So sometimes there was, during the operation, some integration of databases, and so we had to evaluate these aspects. But the fact that common, let's say, behavior, a specific behavior in the day-by-day management of personal data could have impact under a competition perspective or something, okay, maybe in the air, but concretely never evaluated. This decision opens some very new scenarios, and I'm afraid this is one of those decisions that is more important for the question marks it raises rather than for the solutions it provides. And it raises several question marks. In particular, I would say under two aspects, because this judgment has important implication on a purely data protection perspective, but I will focus mainly on those interacting with competition law. One is relating to what Anna Maria just said. So the principle has been established that a competition authority during a competition investigation is allowed to evaluate, if necessary for the evaluation of the case, to evaluate the correct management of data protection by one of the undertaking, and this is not, let's say, against the prerogatives of the data protection authorities, but the competition authority must, in case there is no already defined judgment, involve and consult the privacy authorities to get their perspective. And when I read those paragraphs, my first question was, okay, but which privacy authorities should be consulted? Because, of course, if the problem is only national, no issue. But honestly, the processing of personal data purely on a national basis are very, very rare. When there is a transnational implication in the data processing of personal data, what is or are the privacy authorities to be involved? And this is not a purely theoretical question, because unfortunately, and I believe this is the main point of weakness of the GDPR, contrary to, for example, to what happens in competition, where there are national competition authorities, but then there is the European Commission, that when the problem as a European, let's say, is of European interest, can take over the case and decide. And the result is that more or less in Europe the concept of abuse of dominant position is clearly harmonized. In data protection this is not applicable. There is no European privacy authority, and there is no mechanism that at a certain point allows, where there is a transnational processing of personal data, there is the possibility to have one final, apart from the European Court of Justice, but that's a long process, that can decide. And this is at the moment moment a big problem, because several privacy authorities have different point of view, sometimes conflictual point of view on the application of some key aspect of the GDPR, and I'm going to provide an example in a few seconds. The second part that is very important is the last part of the judgment, when the Court of Justice talks about the relation between competition and data protection, with specific reference to a very detailed aspect, the obtainment of the consent for the processing. I'm sure, of course, that the audience is made of experts of antitrust, but maybe not necessarily of data protection. So just let me remind two key aspects to be considered to understand the consequences of the decision. First, in order to process personal data, any data controller needs a legal basis. The list of the legal basis is provided by the GDPR, is closed. One of these legal bases is consent. But contrary to what maybe most people think, consent should be, in the scheme of the GDPR, a residual legal basis. Should be applied because more invasive for the data subject and so on. So it should be used only under certain circumstances. The GDPR is based on the principle of accountability. So the data controller has to carry out its own risk assessment, and at the end decide what legal basis should be applied to a given processing of personal data. The second key aspect to be considered is, if consent is to be used, the key requirement is that consent must be freely given. And a consent is not freely given when there is an imbalance between the data controller, and the data subject. And this imbalancement causes the fact that the data subject is not really free to provide a genuine consent. The typical example is in the relationship between employer and employee. The employer cannot base the processing of personal data of the employee on the consent, because an employee is not supposed to be free to give or not to give the consent. This is exactly the point where this judgment of the Court of Justice intervened, because basically it says, dear data controller, be careful, because the fact of holding a dominant position can be one of the elements to be considered to evaluate if there is balance or not between your position and the position of the data subject who is supposed to provide the consent. If this is very clear in theory, it becomes quite problematic in practice. And again, I can give an example from my sector. For example, clinical trials. For a pharmaceutical company, of course, clinical trials are a key activity, because we need the results of clinical trial to register the product. And the purpose of a clinical trial is to generate personal data, basically. Even before the MITA decision, there was and there is a huge debate on what is the correct legal basis to process the personal data coming from a clinical trial. And we have completely opposite position from one privacy authority to the other. There are some, for example, the Italian Garante, saying consent is the right legal basis. You must get the consent of the patient taking part in the clinical trial. It provides some exceptions, but that's the rule. There are some other European privacy authorities, for example the Netherlands, which says consent cannot be used to process personal data coming from a clinical trial, for the reason that the position between the pharmaceutical company and the patient is not balanced. The patient is in a weak position. Maybe the trial could be the only possibility to save his or her life, so it's not possible to use the consent. And so in this case, what is the potential evaluation that a competition authority that was supposed to evaluate a potential abuse of a dominant position evaluate? We can have the very same clinical trial for which in one country a legal basis is used and in another a different one. But even assuming that, for example, consent is the correct legal basis for the processing of data coming from a clinical trial, what's the extension allowed for the consent to be collected from the patient? I try to be more clear. Of course, the clinical trial is organized for a specific purpose, register the product, and I can ask the consent for this specific purpose. But then it could happen that some years later, the same data could be useful also for another research, for another purpose, and so on. But one of the key criteria, again, from the GDPR is that the consent must be specific and the subject must be able to understand exactly what the use will be. This is the problem of the so-called secondary use. I get the results for one purpose, but I want to be free to use the same data later on also for other purposes. This is again another point that was very debated and is still very debated, because there are some privacy authorities with a very strict approach. Now you can ask the consent just for the specific purpose of the clinical trial, and others that understand more the need also for scientific research, that could be absurd to limit the use of the data for that specific purpose, while it could become useful in the future for other kind of researches. But in this case, the doubt from Mita is okay. But if I have a dominant position, this will imply that I should reduce and I should not be able to get a wider frame for the consent that I am collecting. Or not. Again, those are unfortunately only question marks. I don't think that the MITA decision provides answers on this. But for sure, in all those sectors where the GDPR has not provided a clear framework, and already as a privacy officer, we had huge problems in identifying and trying to find a solution among all the different point of view of the different privacy authorities, having to add the problem that if I have a dominant position, this could lead to further problems under a competition perspective, makes the balancement that Anna Maria was referring to between the needs from antitrust and data protection even more complex to achieve.
Thank you, Mauro. And I mean, just for the antitrust specialist, I mean, I think the other big area where we meet, the two words meet, is of course in the context of cartel and cartel investigation. I don't need to tell you what happens when we go in and say, give me all the data of all your employees. I need to image all their computers, and then the data protection officer of the company say, whoa, 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 no. We need to get their consent, and you're like, I'm not going to ask their consent because I need to make an immunity application in Brussels. They cannot know this. So it is becoming very complicated, and I think it requires, what we see just is that in order to make decision, and take decision within the company, I think we all are becoming much more exposed to both areas of laws, and also knowing a bit what are the considerations that can, differ depending on what is the priority for the company. But I think it's a very interesting point that also this morning we heard how data, GDPR, and there is too much, a lot of mix between what used to be two parallel words, but now are, words that are coexisting. I don't know if others have comments on this.
No, I mean, just one on this pharmaceutical space, because the issues that Mauro has just raised are particularly acute in the pharmaceutical industry when it comes to market definition, right? Because if you go at the ATC5 level, which happens sometimes, meaning by molecule, it is highly likely that you will end up being dominant anyhow, and therefore with all the implications that Mauro was highlighting. So I'm conscious of time. I would like to know whether there are any further comments on anything that we have discussed.
I mean, on the Meta case, I guess one of the questions that it leaves for me is it, do we have to start thinking about other regulated areas? So is it just that if you're not complying with GDPR, you can be found to have abused a dominant position? Or, are we going to start thinking about whether other areas of regulation raise the same question, where you're not, where there's a question mark over whatever industry you're in, you could get yourself into trouble under 102 on that basis, and it would raise the same challenge of how does a competition authority assess your compliance with a different area of regulation. So, yeah, I mean, that's a question I don't know the answer. And then I suppose maybe to kickstart a discussion, I mean, I suppose thinking about the session that we had this morning as well, and some of the topics that we discussed today, it feels like there's some really fundamental questions being asked now about antitrust. We've you think about we've gone from, I guess, maybe traditional antitrust was, is this merger going to result in higher prices? And all of a sudden we now need to think about a whole load more parameters of competition, about data, about how you factor in innovation, about how you factor in markets that are characterized by ecosystems. We've obviously had, over the last few years, the debate about how do you bring in sustainability considerations. We've had the digital debate, and that's led to the DMA. And then now I think, and this is something that came up this morning, is that there's a real change in the geopolitical environment, and whether that impacts on how we need to do things. I think inflation challenges, cost of living, certain industries now facing particular challenges, especially in Europe, when we think about European competition and the competitiveness of Europe against Asia, against the US, that starts to raise questions about whether, I think that antitrust lawyers have historically sort of taken quite a purist approach and said, industrial policy shouldn't impact on antitrust. There needs to be rigor, there needs to be certainty for business. If you bring industrial policy in, you're creating uncertainty. But I think now there's a bit of a feeling that maybe the way that we've been approaching antitrust and merger control for the last couple of decades, 2-3 decades, isn't reflecting some of these broader concerns. And I don't know whether some competition lawyers might change their view and think, well, actually, competition authorities do maybe need to be more synced up with other regulators or other policy, other governments and bodies that are dictating policy to make sure that competition law is not is consistent with kind of the broader needs of society, of business, of economies. So, yeah, I think that's what I was thinking as we sat through the first session this morning and then this discussion.
Thank you very much, Nick. And so we hope we've solicited your curiosity and given some food for thought in the limited time available. And thank you. Thank you to all the panelists as well. Yes, sure.
Oh, I was lucky. Yeah, I'm from a competition authority, and I was a little bit curious about the experience you have about the monitoring trustee question. And of course, Anna-Maria, I guess I'm one of the culprits. We are not very happy with behavioral remedies, but we have actually accepted 2 such cases quite recently. But there were 3 challenges in this this solution, having the monitoring trustee and having this thing work. And the first challenge was actually to find the right person or company, because the best people were usually conflicted. And maybe that's not the top priority in your career. So that was the first challenge. The second challenge was to work out terms of references that were clear enough for this thing to actually work. And there's a balance between being very detailed and also being general, because you cannot foresee everything. And the last and third challenge, that was actually access to information to this monitoring trustee. I guess this would be different in different markets, but this monitoring trustee needs some rights to have a look inside the parties, the company who's actually accepting this remedy, but also the complainants. And sometimes if there is a great pool of potential complainants, it might be worthwhile to actually give the rights to the monitoring trustee to be proactive, not just reactive in collecting these complaints. So these 3 challenges, do you have any best practice ideas for how we more easily can overcome them in the future? I would be very happy. Perhaps others would be interested also in hearing them.
So I'm not a competition regulator, of course, so I sit on the other fence. So what we see, so as you know, Brussels has a template when you appoint a monitoring trustee. So generally, the Commission doesn't like you to diverge too much from, how the trustee works. I think what we face as, I wouldn't say it's a challenge, but the challenge is really finding the right person. And what I mean is that each industry will require different skills. And I think what we have seen over the years is the willingness, at least in Brussels more and more, to have technical experts, to Nick's points, assisting the monitoring trustee. Because, to be honest, some of this conversation about how many megahertz can you emit on a radio and, what is the various frequencies, well beyond my pay grade. I don't know what it is. neither the monitoring trustee, to be honest. So the technical expert is really the dialogue. And what I would say to, one of the points to overcome your challenges is also a bit openness by the regulator to let the monitoring trustee do their work, and they do it, the more they get a bit of leeway, the better they do the work. Some monitoring trustee, and that's probably my reservation, are a bit strict. And what I mean by strict is not that they shouldn't look at complying with the commitments, but they are not really open to a dialogue. They just, they tell you have to go through the case team, and then I'll tell you, and they are quite fearful, or at least scared of the Commission not being happy with what they are doing. Others are much more open to dialogue, and in particular on behavioral commitments, you need to speak with them, because trust me, there are complainants always. Who says you're not complying with the commitments, and I don't like how you define this and how you define that. I think in practice we have found they can take position, but it's always, because they are the eyes of the regulator, I think there is a limit to how far they can go on their own will. They always have to go back and ask. And after 5-6 years, I think the case team has forgotten what it is that they negotiated with the parties. So I think that's where it comes the challenge, and probably why some regulators are quite reluctant to accept behavioral commitments. Because it requires, sometimes I also need to go back to the commitments that actually I wrote together with the parties, but I don't remember after years what it is exactly that you have agreed. And one of the points, that's why I was discussing about waivers, we see it more and more coming up. And sometimes the waiver is not waiving the commitments, it's about, like one of these requirements is not applicable anymore, or the market has changed. So I think that's also something that will help the monitoring trustee in their job.
On the part of the question about access to information, at the end of the day, you got your transaction approved on the basis of commitments and the appointment of a monitoring trustee. So, from my perspective, you have to allow them enough access to be able to do their job. And I can see that there might be times when parties would say, I don't understand why you need that, or you shouldn't need that in order to do this. But I think you also have to bear in mind that they've got to be, they do have to be able to do their job, and you've signed up to commitments that that say you will not only give access to the infrastructure or to the technology or whatever it is, but you will appoint a monitoring trustee to make sure that happens in the right way, and that ultimately the regulator's concern is addressed. So I think you do have to cooperate, and then you have to be reasonable, and ultimately the regulator will tell you, the trustee will go back to the regulator and say to them, we can't get the information that we need to do our job properly, and that's that. So
it's a good job. I think more people should be monitoring trustee. It's well paid, and you just have to check compliance. But anyway.
Another question?
Hi there. Yes, Christina Barbo from Microsoft. I'm looking forward to my retirement as a monitoring trustee at some point. Having come from a regulated industry in telecoms, it was going to be a comment and a broader question. The alignment between the regulatory regime in whatever form we're looking at, plus also broader points around privacy and sustainability and so forth. I think it's just interesting that the competition law is opening up beyond the previous pieces that we have traditionally known around consumer welfare and the bits that we understand. So it was just, my question was just more around new theories of harm or the latest in new theories of harm, and whether and how the panel has any views on how they'll be developing going forward, bearing in mind this point about the openness of competition and the fact that all sorts of things are being pulled in for consideration, as well as the challenge that we're potentially seeing through the DMA process of competition law being unable, in inverted commas, I don't agree with this, but unable to deal with the problems that people have identified. They're very big topics, but I just wondered whether you had any sort of views on the ecosystem theories of harm and all this pushing of the boundaries of the current regime that you may want to share.
Maybe I can have a start. these are really interesting and high level and broad points, and touch upon what was discussed also earlier this morning. My personal view is that antitrust should not become too broad in itself, so the role of regulation will be important. But even assuming that we will have proper regulation, so regulating ex ante from an antitrust perspective, what needs to be regulated, so DMA, for instance. Then I think there's also an additional issue which needs to be considered, which is jurisdiction, even among the various authorities. And DMA is a good example, because DMA, of course, focuses on the European Commission clearly. But as far as I understand, there have been already a number of national authorities saying, hey, wait a moment, we will have our own, role in here. So, for instance, to give an example of what I see happening in Italy in that space, so the authorities might be looking for different instruments, and I'm referring in Italy to the abuse of economic dependency, for instance. So basically, point is, if antitrust becomes too broad, that is an issue, is a problem in my view, for the reason we've discussed. Regulation would be a good plan B, ex ante regulation, but that needs to be good regulation with very well defined boundaries in terms of scope and in terms of jurisdiction, and that is not necessarily always the case in my view. I don't know if there are any further comments.
Yeah, no, I would agree. And also, I mean, you have regulation like the DMA, which is, of course, an implicit acknowledgement of inability of competition law to fix something, and so regulation comes in. And you have another set of rules, like if you take the GDPR, which is really around a completely different space within the rights of companies and human beings, which need to coexist, which is a slightly different relevance. And also in the telecom world, you have all the telecom regulators that always have a say, but they also look at different considerations. I think where I see the challenge is, to Lucio's point, is not only about expanding or trying to expand the role of competition law, it's really the challenges for companies to make all these regulatory frameworks coexist in a way which is more or less compliant across the board, but it will never be 100% compliance across the board because it's impossible.
Yes, maybe I can just add a reference to what you mentioned. For example, another chapter is sustainability. For example, my group is my company is a benefit company, B Corp certified, and we have coming from this kind of, not regulation, because it's not regulation, but commitments that we have, certain requirements that sometimes conflict a bit with in terms of interaction potentially also with competitors and so on activities that theoretically could be problematic, but in practice not. The new guidelines on the horizontal cooperation has provided some guidance on this, and this is very good piece of news, because it provides some clarity on this. But again, it will be more and more important to have clear indications on that, because sometimes just the law cases and the jurisprudence can be problematic to be managed and applied.
Just for me, I mean, clearly, technology, every industry is technology now, but innovation is endless. So there will always be new theories of harm because there'll be new business models, and so that doesn't stop. I guess there's a question of how the DMA pans out in practice, and whether that causes some of the companies that are in scope of that to sort of alter their behavior to comply, and then it turns out that people still aren't happy or think there's still a problem, and then are you back into a situation where, we thought this would be caught by the DMA and it's not, so now we've got to go back to finding a way to use the traditional tools unless there's going to be more new tools. So I guess I can see maybe some sort of loopholes appearing around there where we have to look at issues again under antitrust. And then my last thought was someone said to me earlier this week, I think it was in the context of sustainability and talking about the need to adapt to the way that antitrust rules are enforced to make sure that we're not preventing legitimate sustainability initiatives. But I had a law firm partner in Brussels say, well, be careful what you wish for though, because the more that then regulators are looking at those things, and then they're starting to sort of draw lines about, okay, what is okay, they will then focus on also on things that they say, well, hang on a second, but that is not okay. And, you know, I've heard rumours that there might be some investigations starting into agreements which were positioned as sustainability agreements, which have kind of come out of the kind of recent discussion and scrutiny on that issue.
Maybe we have time for just very short question, very short round.
Yes, sorry to keep everyone from lunch, but I'm Bert Willekens. I'm an economist at the Belgian Competition Authority, and I'd like to raise, I think, one very important question regarding the labor market discussion. Isn't the right question, instead of asking should we pursue these cases by object or by effect, shouldn't we take a step back and ask, are these courts applying the right welfare standards? We've gotten so used to use the consumer welfare as the welfare standards, and everyone agrees if there's competition in the market, there's a price. If two firms make an agreement that the price is higher than the competitive price, this is wrong, by object. Now, what is a wage? It is money that companies give to workers. If two firms, and this in a competitive market, there's a market wage. If two firms make an agreement to pay workers less, it's basically taking away money from workers and putting it into their own pockets. Why shouldn't that be wrong by object? And why should we prove an effect if we're hurting people in that way? And why shouldn't we prove an effect if it's by the price that they pay? Because it's maybe even worse, because people can choose to buy a product or not, but if you're working somewhere, you're really dependent on these firms. So I think we should pursue these cases by object, and we should just explain better to the courts and everyone making the decisions that they should apply the right standards, welfare standards, to make the assessment. So that's my opinion, but feel free to disagree.
I'll take that. So I hear you. I mean, we could be discussing here about, you know, broader policy issues, hipster antitrust, you know, about bigger issues at length. I hear you. I mean, having seen the outcome in court, whatever test we apply, be it consumer harm or anything else, it would help, you know, everybody to understand a bit better what the anti-competitive effect is, actually, even if a national competition authority decides to pursue the case by object. I appreciate that there might be even procedurally a number of reasons why a national competition authority or even the European Commission might decide to pursue a case by object. Fair enough. But we've seen many cases which, even though in principle the case is, you know, a by-object case, then as a matter of fact, as a matter of additional line of argumentation, authorities provide the reasoning why, in any event, there would also be anti-competitive effect. In any event, if that was the case, that would be helpful for the National Competition Authority as well. It could facilitate follow-on actions or whatever. So a more rounded kind of reasoning would help, not necessarily focusing on consumer harm.
I think we are done. I'm just conscious of time. I just wanted to say thanks, everyone. Thanks also for the question. Thanks to Lear and the organizer for bringing us again here. So, buon pranzo.
Thank you.
Ogni eventino ce n'è ormai una collezione di tagli.
Mia sorella, devo dire la verità, per questo ci ho dato la sciarpa.
Vabbè, ma quella è un po' impegnativa da mettere.
No, vabbè, però belli i colori, sono belli. Thank you.
Grande